me, or do you want me to introduce myself?
Yeah, I'll introduce you.
Oh,
Thanks.
okay, yeah.
Yeah. Okay, I think I'll start with the introduction at least. Welcome everyone to the Special Education Legal Clinic. My name is Mark Weiker. And today we have a presentation from Renee Stromsky. The presentation is Texas v. Becerra and the Future of Section 504. Before we get started, just a couple things. The registration is, I'm going to put it in the chat box here. The link that you most likely use to register is lawyersforstudents.com/legal clinic. That also is a page that has the full schedule of workshops, and we are scheduled through August, which is coming up soon. And we'll have probably a new schedule, beyond August into 2026, I would say by midsummer or so. And a couple things, we can try to answer questions through the Q&A. So if you do have a question through the course of the presentation, please drop it in the Q&A, not the chat, if you can remember. And then some of us, the panelists, will be trying to answer those questions to the extent we can. And if we can't, we'll hold some questions to the end for Renee to answer, assuming we have some time. I think it'll be a little tight, so it's a little bit up in the air in terms of whether or not we're going to have time for questions at the end. But again, we'll try to answer those as they come in writing on the Q&A. Let's see. There is closed captioning available. It's a button on the bottom. If you click on Show Captions, the captioning is available individually on your computer. And if you want to sign up for any other workshops, any of the others that we have scheduled through August, you can use that link in the chat box there. And I think that covers everything. And with that, I'll turn it over to Renee Stromsky.
Thank you, Mark. Good afternoon, everyone. I hope everyone had a good holiday. If you celebrated any over the past week or so, I'm going to, like Mark said, be talking about the Texas v. Becerra case and the future of Section 504. I know there has been, you might have seen on social media or in the news, there's been a lot of press coverage around this case that's been brought challenging Section 504. So I wanted to do a deep dive today and give you guys an overview of the Rehabilitation Act and Section 504, just so you have a better understanding of what it says, what it does. And then I will go into the U.S. Department of Health and Human Services proposed rule change that essentially amended the regulations of Section 504 to include a more expansive definition of disability. And then I will talk about the lawsuit that Texas and 17 other states, or 17 states total, I just forgot, but a good portion of states brought against Xavier Becerra, who is the Secretary of HHS, which I will be using as the acronym for the Department of Health and Human Services, as well as the department as a whole. And then I'll be talking about at the very end implications for what happens if the plaintiffs, Texas and the other states win, and what will be the implications if HHS wins in this case. So like I said, I'll start with an overview of the Rehabilitation Act in Section 504. The Rehabilitation Act was originally enacted in 1973. And as most of you probably know, coming into this act prohibits discrimination on the basis of disability. Um, it has quite a few sections. Of course, I'll get into Section 504 a little bit more thoroughly in a second here, but there's several different sections, of course, within the Rehabilitation Act that protect disabled individuals from discrimination in various programs and activities conducted by federal agencies. So we have Section 501, for example, prohibits employment discrimination against people with disabilities in the federal sector. So federal agencies cannot discriminate against people with disabilities in the course of employment or application for employment. We also have Section 503 in the Rehabilitation Act, which prohibits employers that have contracts with the federal government or subcontracts with the federal government from discriminating against employees or any applicants with disabilities, and also requires those employers to take steps to hire, retain, and promote people with disabilities. And then we also have Section 508, which is another big section of the Rehabilitation Act, which requires our different federal agencies information and communications technology to be accessible to people with disabilities. So it's pretty broad, and I'll get into the actual text of what Section 504 does. But Section 504 essentially is what we'll be talking about today, but it prohibits discrimination on the basis of disability in all programs and activities conducted by federal agencies or conducted by agencies that receive federal funding. So Section 504 of the Rehabilitation Act was passed in 1973, like I said, the actual statute itself, but the regulations that were needed to implement Section 504 were not finalized in 1973. So there was about a 4-year period of inactivity and a lot of frustration within the disability rights community. And it actually came from a series of protests across the United States, including a 25-day sit-in at a federal building in San Francisco in April 1977 to demand the implementation of those Section 504 regulations. And the protest really did pressure the government to act. So on April 28th, in 1977, the regulations for Section 504 were signed, and it marked a significant victory for the disability rights movement. And this really, this was our first Civil Rights Act and our first implemented protections for people with disabilities in the United States. So I have the language of the original statute here. And I'll read it straight to you. I hate reading from slides, but I'm going to read it to you so that you get the exact wording of it. Section 504 does state that no otherwise qualified individual with a disability in the United States shall, solely by reason of his or her disability, be A, excluded from the participation in, B, be denied the benefits of, or C, be subject to discrimination under any program or activity receiving federal financial assistance. The implementing regulations, the different federal agencies have regulations implemented under different chapters of the Code of Federal Regulations and how that kind of describe how they're going to implement this statute. Most of them essentially look the same as the statute itself, but there's differences between the agency, a little bit of differences in language between the agencies, and we'll get into that in a couple of slides. But we're talking about the Department of Health and Human Services today. Their Section 504 regulations look pretty similar. There's a little bit of difference in language, but it still says that no qualified individual with a disability shall, solely on the basis of disability, be excluded from participation in or be denied the benefits of the programs or activities of a recipient of federal funding from HHS, or be subject to discrimination by any recipient. And what's kind of in block letters I should have put there is recipient of federal funding from HHS. So really, what does that mean? And I'm going to take a sip of water. Really, what does that mean? Who is protected? You'll note that I said qualified individual with a disability. To qualify as an individual with a disability under Section 504, you must be an individual that has a physical or mental impairment. So it's two elements essentially. It's having a physical or mental impairment and the second part is that substantially limits one or more major life activities. So having just a diagnosis, in some cases, having a diagnosis is enough. There are regulations within there that say, for example, having autism significantly limits a major life activity such as brain functioning. And so that one is, but just having a disability does not automatically necessarily uh, mean that it substantially limits one or more of your major life activities. In a lot of cases, it does, though, of course. Not only does it cover individuals who are currently experiencing a disability or currently fit that definition, but it also includes individuals that have a history of having such an impairment or individuals who are regarded as having such an impairment. So if, perhaps you don't have, for example, perhaps, and I'm just kind of using this as a basis, perhaps you do not have autism, but people regard you as having autism and discriminate against you because of it, even though you don't have autism, because the people who are recipients of federal funding are regarding you as having that impairment, you can still be covered under Section 504. And who must comply with Section 504? Well, it's any entity or program receiving federal funding, and that's federal funding in general. But also, of course, we're talking here in the scope of HHS. But really, any entity or program receiving federal funding would include public schools and universities, which most of us are familiar with as we're talking about special education, hospitals and clinics, social services and child welfare programs. It's protected under transportation authorities, and of course, our state and local governments. So what are the protections of Section 504? The big one that we talked about is, of course, non-discrimination, and that just means that individuals with disabilities cannot be treated differently or unfairly because of their disability. It also ensures equal access as covered programs, and that just means covered programs that receive federal funding or federal agencies have to ensure that people with disabilities are able to access and benefit from their services. A big one we're also familiar with that Section 504 does is it changes or is reasonable accommodations, which are essentially changes or adjustments that have to be made in order to allow individuals with disabilities to participate fully. Reasonable accommodation examples include modifying policies, for example, to allow service animals to be on campus, creating accessible buildings, for example, just ensuring that there are working elevators to access all publicly accessible floors, and even providing auxiliary aids to facilitate effective communication, such as interpreters or assistive listening devices. An important thing to note about reasonable accommodations as well is that in order for an accommodation request to be considered reasonable, it cannot fundamentally alter the nature of a program or service. And then finally, we have integration, which Section 504 says that services should be provided in the most integrated setting appropriate. In terms of school and in terms of special education, a majority of us where we see Section 504 come in is those Section 504 plans. If a student qualifies as having a disability, qualifies as having an educational disability under Section 504. They are entitled to a Section 504 plan with accommodations that can help them ensure that they have equal access to their education. And, some common accommodations that we see on those Section 504 plans can include extended time on testing, separate rooms for testing, I was going to say, let's see, perhaps again, a policy change for if there is a food allergy, some sort of accommodation that, there won't be any, if it's a nut allergy, there won't be any nuts in the classroom. And then another place that we see Section 504 pop up in school, that is related to equal access, and sort of integration, I guess. But Section 504 also protects our students with disabilities from being unfairly disciplined. There is a requirement that students with disabilities are not suspended or expelled or just excluded in general from school for more than 10 consecutive days or 10 days throughout a school year if the behavior is all related to if the behavior of the incidents are related to one another. A school must hold a manifestation determination review, which is a meeting that goes over the student's disability, the nature of the behavior that was subject to disciplinary action, and if the school determines that the student's behavior was uh, a manifestation of their disability or significantly related to their disability, then they cannot be, suspended or expelled or excluded in any way for over 10-day period. At that point, maybe we should talk about getting on an IEP, a change of placement, um, and things like that. But that's where we see our Section 504 protections in school mostly, and why it's very important in the realm of special education. How is Section 504 enforced? Of course, we have filing a federal lawsuit in order to, enforce any law. You're going to file a lawsuit if someone's not following it. But of course, that takes a lot of time. It takes a lot of money. So there are enforcement mechanisms within each agency or department, within each federal agency or department, for uh, individuals to be able to submit administrative complaints to whatever federal agency is providing funding to the entity that you are alleging violated Section 504. So for example, we have if the program, like a public school, is receiving federal funding from the US Department of Education, then you would file your complaint with the Office for Civil Rights in the US Department of Education. HHS, which is the department we are talking about today, also has an OCR office. OCR is Office for Civil Rights, as well as the Department of Transportation, the Department of Housing and Urban Development. And then, of course, we have the Equal Employment Opportunity Commission, the EEOC, which covers workplace discrimination. And what kind of remedies are you entitled to if if there is a violation found of Section 504? You may be entitled to injunctive relief, which essentially means that a court or essentially, a federal department can order that the violating entity immediately either refrain from discriminating against you or allow you to participate in a program, use an accommodation as soon as possible. Remedies we typically see are policy changes, especially through those departments. But we'll see policy changes to ensure that not only the individual that has complained is able to move forward with accessing the program without experiencing discrimination, can be able to access the program without experiencing discrimination, but so that it affects the larger group as well, and that if anyone else comes into contact and has this issue in the future, they hopefully won't, because there will be some policy changes. There is sometimes monetary damages that we see with Section 504 enforcement. For example, if a federal agency, let me think of a quick example. If, for example, you lost out on, I guess this would be more related to employment, but if you were losing out on employment opportunities because the Rehabilitation Act was violated, you could be entitled to monetary damages in the form of lost wages. I did put a note on here that Section 504 for monetary damages unfortunately does not include emotional damages. There is no right to seeking out emotional distress damages per the US Supreme Court case in 2022 of Cummings versus Premier Rehab Keller. And then you are also entitled to reimbursement of attorney fees. So I will talk a little bit about the May 2024 amendments to Section 504, and this is from May 2024, so about a year ago. HHS had issued new amendments to Section 504, significantly expanding non-discrimination protections, and this was particularly for individuals with gender dysphoria and other health conditions related to gender identity. Hopefully you can still read my screen. I know there's a lot of information on this slide, so it might be a little small. But in September 2023, HHS had initially proposed the rule that was finalized in May 2024, as I said, and became effective as of July last year. And in that rule, HHS clarified that gender dysphoria may qualify as a disability under Section 504. Essentially, that means that federally funded programs cannot discriminate against individuals based on gender dysphoria or limit their access to necessary care. This also requires recipients, the new rule, in addition to expanding the definition of disability to include gender dysphoria, also expanded recipients' requirements and recipients of federal funding from HHS, but it required them to administer a program or activity in the most integrated setting appropriate to the needs of a qualified person with a disability. So this really, again, just emphasized integration, and the purpose of it was to avoid at all costs, essentially, institutionalizing people with disabilities. And like I said, since this is an HHS specific regulation, it applies to only certain settings receiving that receive federal financial assistance from them. But it also, they do provide federal financial assistance to a lot of different programs, including childcare, preschool, elementary, and secondary programs, and adult education programs, as well as our post-secondary educational and vocational programs. And of course, it does apply to what you might more expect uh, of recipients of federal funding from HHS, which would be health, welfare, and other social service programs or activities, as well as, again, just broadly in general, every recipient of federal financial assistance from HHS. Are all covered by this new rule. So let's look again at Section 504 definition of a disability and see what changed. So right now, under Section 504 in the Department of Health and Human Services, there is a subsection underneath the definition of disability, which we talked about earlier, was individuals who have a mental or physical impairment that substantially limit one or more major life activities. Underneath of that, there's a lot of other qualifiers, a lot of other exclusions. One of the exclusions is that the term disability does not include terms set forth at 29 USC 705 subsection 20F, which actually is the ADA definition, or is from the ADA's definition and exclusions of the term disability. That section of the ADA says that an individual with a disability does not include an individual on the basis of transvestitism, transsexualism, pedophilia, exhibitionism, voyeurism, and gender identity disorders not resulting from physical impairments or other sexual disorders. So this definition of disability still remains today within Section 504, even with HHS's proposed updates. So what changed? There was a case in 2022, Williams versus Kincaid. This was a case that challenged I think it was out of Virginia. Yes, it was out of Virginia. The case challenged the placement of a transgender woman, Keisha Williams, who was placed, at first, she was placed in the women's prison, but she was ultimately moved to the men's side of the prison in Virginia and was denied all care related to her gender dysphoria, which was well, which within the case was considered a disabling medical condition that affected many transgender people. Um, and so Williams challenged this. The lower court in Virginia denied it and said that because of the definition of disability under the ADA and under Section 504 stated that gender identity disorders not resulting from a physical impairment were not considered a disability, that her gender dysphoria could not be considered a protected disability. Williams appealed this to the Fourth Circuit, and the Fourth Circuit actually reversed the decision of the lower court and found that gender dysphoria can be considered a protected disability under both Section 504 and the ADA. This is because the text of the ADA, when it was written and currently, although it does specify gender identity disorders, it did not define it specifically and did not mention gender dysphoria at all. As we saw, that gender dysphoria was not within that list. So when the Fourth Circuit was determining whether the gender identity disorders that was listed within that exclusion from the identification of a person with a disability, whether that included gender dysphoria, the Fourth Circuit really looked to the meaning of the ADA's terms at the time of its enactment, which I should have written down, but I believe it was 1990. So they were looking at whether when Congress was writing ADA back in 1990, did they consider gender dysphoria to be included within that definition of gender identity disorders? Williams versus Kincaid, the Fourth Circuit here, said that it wasn't, that it did not include gender dysphoria, and they actually used the transgender discrimination employment case from 2020, Bostock versus Clayton County, which essentially added protections for transgender individuals in terms of federal employment or in terms of employment, who also determined that when the ADA was considering what the definition of gender identity disorders, they did not include gender dysphoria. Essentially, they were saying that the definition of gender dysphoria that we have now, that was updated in the DSM-5, the Diagnostic Statistics Manual, the definition of gender dysphoria in the DSM-5 was differing dramatically from the now rejected diagnosis of gender identity disorder from the DSM-3. Essentially the definition of gender identity disorder in the DSM-3 specifically focused exclusively on a person's gender identity, whereas the DSM-5 defines gender dysphoria as the clinically significant distress that is felt by some of those who experience an incongruence between their gender identity and their assigned sex. So in short, being trans alone is not enough to sustain a diagnosis of gender dysphoria under the DSM-5, as it was as it could for a diagnosis of gender identity disorder under earlier versions of the DSM. Before, if you were trans, you could automatically qualify for the diagnosis of gender identity disorder. With the DSM-5, not only do you have that the experience of an incongruence between your gender identity and their assigned sex, but there's also that clinically significant distress. So, for example, if a transgender person does not experience that clinically significant distress, then you cannot be diagnosed as having gender dysphoria under the DSM-5. And that's really where HHS, their response was to agree with the Fourth Circuit's ruling that gender dysphoria is different from that gender identity disorder and can qualify as a disability. They specifically wrote in the Federal Register that when they wrote this new rule, that restrictions that prevent, limit, or interfere with otherwise qualified individuals' access to care due to their gender dysphoria diagnosis, or a perception of gender dysphoria, as Section 504 covers individuals who are regarded as having such an impairment. Any type of discrimination related to that may violate Section 504. HHS stressed that disability protections only apply if again, gender dysphoria substantially limits major life activities because not only do you have, like we talked about in the definition of a disability, not only do you have to have that mental or physical impairment, but it also has to substantially limit major life activities. And this is determined on not just for people with gender dysphoria, but for everyone. It's determined on a case-by-case basis. The HHS did acknowledge concerns about religious freedom in response to comments on the proposed rule, but pointed out that there are other federal laws that protect religious rights, that an agency or an entity that is a recipient could pursue protections under. So what are the implications right now of HHS's new rule? For individuals with gender dysphoria, this allows stronger legal protections against discrimination in federally funded services and federally funded services through HHS, which includes healthcare providers, hospitals, social service agencies, and like we talked about, primary, secondary, and post-secondary education services. And it also allows greater accessibility to gender-affirming medical care and accommodations. For healthcare providers and institutions, including those institutions that receive HHS funds, which includes education entities, many of them, not all education entities, such as like private schools, but they must ensure compliance with Section 504's expanded scope, or they put themselves at risk of civil rights complaints or federal funding loss if care or accommodations are refused based on their diagnosis. This is where Texas versus Becerra comes in. So like I said, the plaintiffs in this case, the complaint itself was brought by Texas, Alaska, Alabama, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Louisiana, Missouri, Montana, Nebraska, South Carolina, South Dakota, Utah, and West Virginia. Mainly, I just read all of those states too, so I could count, and it is 17 states. So Texas and 16 other states did bring this complaint against Xavier Becerra, the Secretary of HHS and HHS as a whole. And this was filed on September 26, 2024. So about 7 months ago. I can't do math that fast, I apologize. But there's your basic case overview. What their plaintiffs had, I believe, 1, 2, 3, 4. They had 4 issues that they brought up in their complaint. The first issue was HHS's use of contradictory language. So the plaintiffs, again, I'm going to use them as a collective whole, but it's Texas and the other states. They believe that HHS's definition of disability contradicted express statutory language. The rule, of course, includes the new rule proposed by HHS includes gender dysphoria as a disability, but plaintiffs argue that this goes against how the law was originally written to exclude gender identity disorders not caused by a physical condition. They believed that gender dysphoria was too closely connected to the term gender identity disorders, which the ADA and Section 504 both say are not covered unless it's caused by a physical condition. They believed, essentially, the plaintiffs believed that gender dysphoria is a mental health condition that can't be, it's purely psychological, it's not physical, it can't be confirmed or falsified by any physical test, and so therefore it is not and cannot be a disability under the ADA, because it's not a gender identity disorder not resulting from physical impairments. Essentially, the states believe that the DSM-5 simply moved what was previously under the associated features section of gender identity disorders and put them into the impairment and complications section, into the associated features and the impairment and complications of the previous definitions of gender identity disorder and transsexualism, and put it into diagnostic criteria and rebranded it essentially as gender dysphoria, and that because of it, it doesn't make the two conditions distinct enough, with different symptoms or affecting different populations. And that was their issue, was that HHS's interpretation was contradictory to the express statutory language. Their second issue was that there would be a lot more discrimination complaints, essentially. And that their complaint was that the new rule now requires more community-based services. And this goes back to my comment on the new rule requiring services to be provided in the most integrated setting appropriate to the needs of a person with a disability. They believed that because of the new rule also stated that, again, like I said, institutionalization, it was trying to avoid this at all places possible, or it was trying to avoid this at all reason possible. And so because of this, essentially it will allow complainants, or people who are alleging discrimination of Section 504, to be able to bring complaints if they are at risk of being institutionalized, or if there is a serious risk of them being institutionalized, rather than if they are already institutionalized. So the plaintiff's issue with this, the state's issue, was that this rule now forces states to redesign their disability services to prevent even the risk of someone being placed in an institution. But their argument was that under the ADA, states are only required to make reasonable changes or modifications. They do not need to make changes, like I said earlier, that would fundamentally alter the nature of a program or service. And they believe that making this, having this expanded definition of disability and disability discrimination protections would change completely how programs or services in these states work. And they are concerned that this rule allows people to file disability discrimination complaints, even if they're not in an institution or about to be placed in an institution. People with disabilities can now submit complaints just if the way the services are provided could possibly lead to institutionalization in the future. There are also, the plaintiff's third issue is that the challenges created by the new rule are too great. The final rule exposes states to withdrawal of federal funding, which could jeopardize medical assistance programs and penalize states that act in compliance with requirements from other federal agencies. Essentially, states could, if states are refusing to follow the new rule and meet the requirements of Section 504's expanded definition of disability, they're at risk of losing their funding from HHS, and that that health services that many children and adults with disabilities rely on could be put at risk. And the concern again was that when they're when the states are trying to follow this rule from HHS, it may be conflicting with rules from other federal agencies. The final issue is that the new rule could be a burden for employers. The final rule completely disregards according to the plaintiffs, the final rule completely disregards the legitimate interests of federal grantees in preserving the integrity of their programs. It requires states to spend more time and money adjusting policies for employees with dysphoria. This includes, making sure that individuals with gender dysphoria are granted accommodations like using their chosen name and pronouns, updating dress code policies, and allowing access to bathroom that match a person's gender identity, which may interfere with how states usually run their programs. One of the examples that was given was that the Texas Department of Agriculture already has a written dress code and grooming policy that distinguishes between dress codes and grooming practices for male and female employees, and that this new rule would be a burden because it would cost time and money to modify their current policies to match with HHS's expanded rule. So what laws are the states suing HHS under? Count one is that the final rule exceeds statutory authority and is not in accordance with law. Essentially, their first argument is that the new rule goes beyond what the law allows by redefining disability to include gender dysphoria, and that HHS did not properly justify it because it forces programs that receive federal funding from HHS to make major changes to offer services in the most integrated settings possible. And it also changes important things without legal authority by pushing federally funded programs to allow HHS's goals of inclusion of people with disabilities instead of states getting to make their own decisions about this type of area. The second statute was 5 USC 706, and the states argued that the final rule is arbitrary and capricious, which essentially means that they believed that the final rule drafted by HHS was rushed, one-sided, and didn't make sense in violation of our US code. They believe that HHS did not seriously consider how much it would cost states to follow the new requirements. They believed it conflicted with other federal rules and would make it harder for states to know which rules to follow. They believe it prevents states from trying new or better ways to deliver services to people with disability, because of that requirement to provide services in the most integrated setting possible and not be serving programs that that risks individuals with disabilities to be institutionalized. And they believe it sets up a system that is too complex and unrealistic to actually follow, and that it ignores, again, existing federal laws that did not match what the rule was trying to do, and they didn't explain why. The third count, which is the one that's, mostly on people's radar right now and what we're talking about, is they are asking the court to declare Section 504 as unconstitutional. The plaintiffs argue that Section 504 of the Rehabilitation Act, that requires states to follow certain rules in order to receive federal funding from the entity, is unconstitutional because states do not have a clear choice. The plaintiffs say that the law forces states to choose between following the rules or losing all federal funding. This means states might feel coerced into accepting conditions without having a fair understanding of their options. They also believe that the rule lacks clear note, or that Section 504 lacks clear notice. States don't clearly know what they're agreeing to when they accept federal funds because the law doesn't provide enough clear warning or explanation. And they believe that states should be able to knowingly choose whether they want to follow these rules. They also believe that Section 504 is unconstitutional because it doesn't match the purpose of the funds. The plaintiffs argue that the law's conditions don't always relate to the specific goals of the federal funds. For example, when Congress gives money for a particular purpose, the rules should match the purpose of that money. If they don't, then the law can be challenged as unreasonable. Finally, they're arguing that Section 504 is unconstitutional because it takes away state control. The plaintiffs argue that the law forces states to follow federal rules, even if it goes against their own judgment or priorities, and that this is in violation of the 10th Amendment, which says that the federal government can't take over state government functions. So really, in summary, the plaintiffs believe that Section 504 as a whole puts unfair pressure on states and violates their rights by imposing unclear and unreasonable conditions for receiving federal funding. And the final count that they brought was that the final rule, or HHS's expanded definition of disability itself, was unconstitutional because it surprises states with new requirements that aren't clearly explained in the law itself. They believed there was no clear notice and that the rule, like I said, adds new conditions that the states couldn't have expected based on the original language of the Rehabilitation Act. Which means that states are being asked to follow rules they didn't clearly agree to. And they also believe that the states couldn't have knowingly agreed to these changes because they weren't clear and states should have clear notice of what they're agreeing to when accepting federal funds. So what are the plaintiffs demanding for relief in their complaint? They want the court to issue permanent injunctive relief against defendants, which would enjoin defendants, HHS, which would enjoin them from enforcing the final rule. They want to declare that the final rule is oh my goodness, sorry. They want the final rule to be declared that it violates the Administrative Procedure Act. They would also like the final rule to be held unlawful and set aside or vacated. They also want to declare Section 504 unconstitutional and issue permanent injunctive relief against defendants, which would enjoin them from enforcing Section 504. And then, of course, the typical demands for relief that a lot of people will see in complaints like this is the award for attorney fees and any and all relief to plaintiffs that a court deems just and proper. So, and I am keeping an eye on the time, just FYI. So, case status and developments. Like I said, this was just filed in September 26, 2024. And if you have ever heard anything about the court system, you know it's nefariously, what is the word? It is very slow. Notoriously, I don't know. It's usually very slow. So the complaint, like I said, was filed in September in the Northern District of Texas. In November 22, there was a joint motion from both parties to stay or essentially pause the answer deadline for plaintiffs to be able to file a response answer to the complaint. In December, there was another order granting a motion to stay the answer deadline. And then in December on the 15th, the administrative record was filed by by defendants, HHS, which consisted of a certified list of contents of the administrative record for their creation of the final rule. So a little bit of discovery. On January 10th this year, there was an unopposed motion to amend and correct the scheduling order. And then another 4 days later, that order was granted to amend and correct the scheduling order. But then on January 24th, there was an unopposed motion by both parties filed to stay, again, pause all deadlines in light of the January 20th, 2025 executive order called Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government, which, quoting from that executive order, reflects the position of the United States and provides that agencies shall not promote or otherwise inculcate gender ideology. A day later, that order was granted to pause the deadlines. And on February 19th, 2025, a joint status report was filed by both the parties. It essentially stated that defendants, HHS, were continuing to evaluate their position and their response to the case in light of the January 20th executive order. And plaintiffs actually, in that joint status report, the states clarified, and this I put quotes in here because it's directly from that status report. Plaintiffs clarify that they never moved and do not plan to move the court to declare or enjoin Section 504 of the Rehabilitation Act as unconstitutional on its face. Essentially, it means that the plaintiffs are not challenging. What they're saying is that they're not challenging the constitutionality of Section 504 as a whole, nor are they trying to stop the federal government from distributing money under Section 504, but that they're bringing a more limited as applied challenge because they believe, essentially, they believe the way that HHS is interpreting and applying Section 504 in its May 2024 final rule is unconstitutional in certain cases. And plaintiffs argue, again, that HHS is going beyond what Congress authorized in the statute and applying Section 504 in ways that violate the Constitution's spending clause. But again, they're not asking for the court to strike down Section 504 entirely or to stop federal funding under it. However, I'll have a comment on that in the next slide because just last Friday on April 11th, so not the past Friday, but the one before that, a second joint status report was filed as an update. Same exact statement from the defendants that they are continuing to evaluate their position in light of the January 20th executive order. And then plaintiffs, again, the states further clarified that they have no intention to seek any relief from this court on count 3, that Section 504 is unconstitutional, of their complaint. So again, plaintiffs are attempting through this joint status report to narrow the scope of their complaint by saying they're not asking for any relief related to the constitutionality of Section 504, nor are they seeking to impact federal spending or its application to recipients of federal funds, but that they're solely seeking relief related to the final rule that was implemented by HHS. And while this statement helps clarify their position and maybe brings a little bit of relief momentarily, the problem is that there's been no amended complaint. And so there's been no amendments to the complaint that I've seen in the case docket. And I haven't, and of course, I'm not on their side. I'm not, working with them. I don't know if they're trying to develop one right now, but the complaint that was filed in the court still says that their count is for Section 504 as a whole to be declared unconstitutional, and their prayers for relief still include for Section 504 to be enjoined and declared unconstitutional. So again, while the statement maybe clarifies their position, unless they file an amended complaint, then their original claims, including count 3 that Section 504 is unconstitutional, technically remain part of the case. If they want to fully withdraw that claim or remove it from the proceedings, they need to file a formal amendment to their complaint. So what are the consequences and broader implications? What happens if plaintiffs succeed? If plaintiffs succeed, plaintiffs, the states, there would be huge consequences for individuals with disabilities. Section 504 would be declared unconstitutional, which would dismantle a cornerstone of disability civil rights law. It would be the biggest rollback of disability rights since the passage of Section 504 back in the 70s. And protections in schools, hospitals, housing, and employment could disappear for millions of people with disabilities. Schools wouldn't be required to develop Section 504 plans for their students, and they wouldn't be required to hold those manifestation determination reviews to not be able to exclude a student with a disability for more than 10 days if the discipline is related to that student's disability. There would also be limitations on disability discrimination protections, as individuals no longer be able to file complaints of discrimination for being at risk of institutionalization rather than only being able to file a complaint if they're actually facing institutionalization at that time. And there would be less accountability for states' care systems because states would no longer be required to proactively prevent harmful gaps in care systems. And there would be a reactive approach only. States would only need to act after harm or institutionalization has happened and not beforehand. Specifically, consequences for individuals with gender dysphoria or transgender individuals, there would be a loss of federal disability protections. Gender dysphoria would no longer qualify as a disability under the ADA or Section 504. Transgender people could lose access to reasonable accommodations, protection from discrimination, and rights to equal program access. There would be barriers to gender affirming care. There would be no right to accommodations for gender dysphoria in federally funded programs, and states could deny transition related care, counseling, or support services under Section 504 and ADA with no recourse. And HHS's 2024 rule and the DOJ guidance would be undermined because it would reject that evolving medical consensus in the DSM-5 of gender dysphoria as a new diagnosis, including that clinically significant stress, and reverts essentially to the outdated definitions in the DSM-3. It also threatens, again, the legal recognition of gender dysphoria as a legitimate medical condition and reinforces stigmatization of transgender people by labeling gender dysphoria as unworthy of legal protection. a little bit more broadly, this would have a chilling effect on federal civil rights law, as Section 504 served as a model for the ADA and other civil rights statutes that tie funding to compliance, which could threaten Title IX, sex discrimination, Title VI, race discrimination, and parts of the Americans with Disabilities Act and the Affordable Care Act. And it sets a precedent that Congress can't require states to comply with civil rights laws in exchange for federal funding, which empowers states to resist or reject federal mandates. However, what if the defendants succeed? If HHS prevails, it will solidify legal protections for transgender individuals with gender dysphoria and ensure that disability laws evolve to meet modern standards of equity, dignity, and inclusion. It confirms that Section 504 includes protections for gender dysphoria and upholds that at risk of institutionalization standard, meaning states must prevent policies that could indirectly lead to institutionalization. And again, that recognition of gender dysphoria as a disability. Um, and so a little bit more broadly, it sets a national legal precedent because it strengthens agency authority under Title IX, Section 504, and the Affordable Care Act to be able to interpret sex discrimination to include gender identity, like the Supreme Court did in the Bostock v. Clayton County case in 2020 that I talked about, that affirms non-discrimination based on gender identity under Title VII. There would also be continued federal funding with protections, and that requires states and providers to comply with anti-discrimination rules to be able to receive federal funding for Medicaid, education, and health. And reinforces that federal power to condition funds on civil rights compliance under the spending clause. And finally, there's the broader civil rights implications that it just strengthens the legal framework for trans inclusive and disability inclusive civil rights enforcement and could lead to an expanded use of the most integrated setting standards across other agencies. Really, the Texas v. Becerra case stands at the intersection of civil rights, healthcare, federalism, and disability law. At stake is not just the scope of the Department of Health and Human Services authority under Section 504, but also whether individuals with gender dysphoria and people with disabilities more broadly can fully access federally funded services free from discrimination. A ruling in Texas's favor could narrow longstanding disability protections and limit the reach of federal civil rights law. And a ruling in favor of HHS would affirm the federal government's ability to protect marginalized populations, modernize disability law, and ensure access to care in the most integrated and affirming settings. So as litigation continues, this case may shape the future of how we understand and enforce the rights of disabled and transgender individuals across the country. So you will just have to stay tuned to see what the next updates are. And that is all I have. I think I have a minute if there are any very fast questions.
Hey, Renee, that was great. First of all, I did answer some questions in the Q&A. If you want to take a look and make sure those sound right, I based them on what you shared with us.
Yeah.
And I think a few of them even you were answering as the questions were being asked. So I think it was helpful for
I was
me.
going to say, I see one that says, are they going to, after the amendments, or is the implication that the entire law is unconstitutional? In the joint status, in their complaint, yes, they're saying the entire law is unconstitutional. Their joint status report clarifies that they're only going after the amendments, but like I said, until I see, or we see collectively an amendment to that complaint that clarifies that, they are saying they are or are alleging in their complaint that the entire law is unconstitutional. I also see if this is based around or under the spending clause, if they prevailed, would we be looking at IDEA next? Perhaps they could, but like Mark said, Mark's answer is correct that they would have to find a reason that the IDEA is unconstitutional in order to bring a challenge and seek the same relief. But essentially, yes, it does put other civil rights statutes at risk. Another question, if this goes through, once my child graduates and their IEP is no longer active, would they not be protected any longer? If Section 504 was deemed entirely unconstitutional, then they no longer would be protected after they're graduated under Section 504. If it is related to that, which is a very scary reality. And then I was going to say, I also see, I was just thinking that if they were arguing that 504 is coercive or burdensome, that they would not stop there. Yep, and Mark said he would not be surprised by anything, so he understands that sentiment, and absolutely. This is probably the first of many that we'll see challenging rules. There are other litigations challenging rules. This is just the most prevalent to special education right now. So thank you, everyone. And it looks like Mark has dropped information on the next workshop into the chat, which is Monday, May 19th, presented by OCECD on children transitioning from early intervention to preschool. And he put the link to registering right in the chat.
Excellent, Renee. Thank you very much.
Absolutely.
One thing I didn't mention at the beginning is that this will be recorded and posted by the end of the week at the same link that I shared in the chat box. So if you want to rewatch it or share it, you can do that, or any other of the workshops that we've done are also available to watch on demand. Thanks again, Renee.
Thank you. Have a good day, everyone.
Bye-bye.
Bye, Elaine.
Bye.